Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. We're usually here with Ann Lipton, who is our friend and law professor at Tulane in New Orleans. She is traveling this week. So instead, we invited Ben Bates of the Harvard Law School, which I'll explain a little more about in a minute, to join us. Hi, Ben.
Thanks, Mike. Really appreciate the invitation. It's a pleasure to be here.
I am delighted to have you here. Just as a reminder, of course, I'm Mike Levin. I'm an activist investor. I live and work in Chicago. While Ann normally covers the legal end and I cover the financial end, we're going to lean on Ben to cover a very specific legal end of our podcast today. Now, followers of the activist investor, the stuff I write, know that we kind of gushed over Ben's recent paper on advance notice bylaws. And so in Ann's absence, we thought we'd talk to Ben about that paper and maybe a few other subjects if we have a little bit of time. Just as a little more introduction, Ben is a research fellow at the Harvard Law School Program on Corporate Governance. Listeners here know that program mostly through its prevalent and popular daily posts on a whole wide range of corporate governance and financial finance subjects. That's the Harvard program that's headed by Professor Lucian Bebchuk, and he's that distinguished scholar of corporate governance, finance, and activist investing. Interestingly, beyond that, kind of daily selection of writings, the program also sponsors numerous academic research efforts on these subjects, and Ben is one of those research fellows. He has his JD from Harvard, and also interesting, at least to me, his undergraduate degree in finance from Brigham Young. He interned with the big U.S. law firm and the U.S. Attorney's Office in Boston, so he's got some diverse experience beyond academia. Ben, I think I was roughly correct in describing your background there, I hope, right?
Yep. No, you got it. Those are the highlights.
Great. Let's start now with the principal findings, so to speak, from the paper, which is entitled Rewriting the Rules for Corporate Elections. You can find a working draft that I think is getting near completion on SSRN, the popular academic paper archive, and it's scheduled to be published later this year, early next, in the New York University Law Review. So let's kind of hit the highlights, if we may. Go ahead.
No, for sure. So I think it's frankly it's helpful to start with a little bit of background about what this project is and what it's not, and
go ahead.
Kind of how I got interested in this.
Yes.
Your listeners know a bit about advance notice bylaws. I think you guys did an episode about it a couple of weeks ago.
Yes, we did.
And the reason is they're a big deal for activists, and they've been becoming a bigger deal recently with some of the litigation that you guys discussed in the episode. But despite the fact that they're getting a lot of attention from activists, they've gotten very little academic attention. There are a few people who have mentioned advance notice bylaws in papers about other things, but there hasn't been a lot of systematic discussion of what's happening and whether we should be happy or sad about what's going on in practice right now. And especially the data has been very limited. There's a few data vendors. I think DealPoint Data is one, and maybe FactSet is another.
I've seen them. Yep.
Yeah, they kind of track whether companies have advance notice bylaws or not, and maybe what the nomination window is.
Sure.
But as far as these disclosure requirements that are super controversial, no one's
really so there's sort of two ends of it where you observed sort of a big bunch of white space. First, any kind of discussion of the principles or the theory or whatever about kind of how these things work.
Right.
And then any kind of empirical evidence about what they are. And that latter element I want to dive into a little later. I mean, the former I want to talk about too. But all right, so there's those kind of two ends of it. The theory,
those are the
theory
two
and
elements.
the data. Right, go. All right. So you wanted to kind of get things moving, and I think you did. So
good. I'm glad you think so.
Keep going.
Yeah, so that was the point, was let's put the basic facts out there, what's going on in practice. how have these evolved, who's adopting them, and then start thinking about whether the current law makes sense in light of the evidence and in light of what, the theory. So what do I find? The headline finding, which isn't a surprise to anybody who works in the space, is that advanced notice bylaws, their disclosure requirements have gotten longer and more complex over the past 20 years.
And I'm sorry to interrupt you. And I think it's helpful to mention that there's sort of two ends of what we talk about. Advanced notice bylaws actually has two kind of basic parts: the timing disclosure window and the disclosure requirements. Describe both those things very generally for a second.
Okay, yeah, glad you brought this up. This is helpful to say at the beginning. Yeah. So advanced notice bylaws, as you said, have two components. They have a nomination window and then a set of disclosure requirements. And the idea is to let the company know in advance if you're going to be contesting an election. So
nominating directors.
Yes. So most companies, the nomination window says, if you're going to nominate directors, you need to let us know typically 90 to 120 days in advance of the anniversary of last year's meeting.
So roughly 3 to 4. I mean, the idea is you tell the company what you're up to 3 to 4 months before we expect the next annual meeting to take place.
Precisely.
So you can't just show up at the meeting, which we all know, and say, "Hey, I'm nominating people," and bring a bunch of proxies, bring a bunch of votes. So this allows the company to get well ahead of what might be happening. So there's that kind of timing part. All right, go ahead.
So we got the timing part, and then the second part is when you let the company know what you're doing, what do you have to tell them? So there's a list of disclosure requirements, right? And there's totally obvious stuff in there. Tell us your name. Tell us who your nominees are going to be. Right. Do you own stock in the company? Do your nominees own stock?
Right. If you commit any crimes, there's all sorts of stuff that they want to know.
Yeah, right. and a lot of it's reasonable. And in fact, maybe I should mention now, advanced notice bylaws have actually been around for a really long time. Oh, yeah. In the simple form, right? There are cases interpreting these back. I think the earliest ones I found were definitely in the 80s, maybe even in the 70s. Okay. But the basic form, right? Just tell us in advance and tell us who you are. There's a lot of other stuff that's gotten into the disclosure requirements too. Now they ask about, tell us who your affiliates are, tell us who your associates are, right. Tell us, what they're up to.
What kind of derivatives do you own?
What kind of derivatives do you own? Right. Have you had conversations with people? Anyway, it's gotten a lot more complicated as far as the disclosure requirements. That's part of what I look at.
All right. So you started talking about your findings between the disclosure requirements and that timing element of it. Go ahead.
Yeah. So the big headline for the disclosure requirements is that they've gotten much longer and they've gotten a lot more complicated. It's interesting to contrast this with the nomination windows, where practice is actually largely converged.
Oh, interesting.
So you might think, right, if we're thinking that companies have just gotten tougher and tougher on activists over time, that you would see both of these get tougher. It's actually not true. For the nomination window, there used to be actually a lot more variety, and now almost everybody has 90 to 120 days, so 3 to 4 months in advance. And almost always the window is set relative to the anniversary of last year's meeting.
Sure. Okay.
It used to be the case. Sometimes people would have the window in advance of the proxy, when they would say, tell us 90 days before we file our proxy statement.
Yes.
Which pushes the window back further. But that's becoming extinct. It's a lot less common these days.
All right.
Yeah.
So it's also probably worth mentioning that there's no SEC promulgated or Delaware promulgated kind of standard boilerplate that everybody has to use. Each company has largely complete control over what they put in their advance notice bylaws, right? And there's lawyers that kind of contribute, and there's different lawyers that specialize this and so on. But it shouldn't surprise us that each company could have little, and there's going to be trends. There's going to be, if 10 companies all hire the same lawyer,
right,
they'll probably end up with something very similar. but not necessarily
Yeah.
exactly the same. So
Yeah. No, and so one of the other interesting findings was I was pretty shocked at the degree of variability across firms. You know,
for this very reason.
yeah, you might have thought that this is kind of monkey see, monkey do, right? Like
Right.
one person adopts it, everybody else adopts the same provisions, and everyone kind of moves in lockstep each year with the latest and greatest. But you see nowadays in the market, and actually in the next version of the paper, I'm going to include some data to show the distribution
Sure.
of word counts and strength across bylaws
Right.
to give a sense of this. But you have some people who still have extremely basic bylaws, and some people who just, it's 10 to 20 pages, single spaced of
lots of
requirements
stuff.
upon requirements,
Right.
and everything in the middle.
All right.
So this level of variation is something that's a really interesting
So
feature.
let's talk a little bit about the basis, the data that
Yeah.
you assembled to try to get to these kind of findings about convergence of the nomination window and variation in all the terms and so forth. What did that data look like?
Yeah, so what I did is I got a list of basically every company that files stuff with the SEC, every public company.
That's thousands of companies.
We've got thousands of companies, and I whittled it down a little bit, right? So there's these common financial data sets that academics use. So I made sure that I could match the companies to these standard data sets.
Oh, like for share price and balance sheet and that kind of stuff.
For share price and balance sheet.
Okay, got it.
So that narrowed it down a little bit. And then I also restricted it to companies that have at least a 5-year trading history.
Okay.
So it's like I wanted to get trends
So
over
all
time,
the news,
right?
none of the new SPACs are in there. It sounds like.
So there's probably not. This isn't full of SPACs. And then for this list of companies, I think it's close to 4,000 companies.
Yes.
I wrote some code that sucked all the bylaws off the SEC's website,
Wow.
and then did some. So anyway, we ended up. I have a sample of close to 14,000.
Like copies
sets
of
of
bylaws.
bylaws.
So not only do you have the advanced notice bylaws, it sounds like you have all the bylaws somewhere.
Yeah,
In some
yeah. No, I
preliminary
started
version
with
of
all
this.
the bylaws. Yeah,
Right.
and then kind of winnowed it down.
So with 4,000 companies and 14,000 bylaws, there's some trend or some versions of one company's bylaws that you could sort of even track over time, I suppose. All right.
Yeah,
So
and then
go ahead.
yeah, no. So I say I do this in one part of the paper where I look to see whether companies amend their bylaws after an activist files a 13D.
Right.
Right.
Oh, cool.
So to look and see, like, an activist shows up, do you crank up your bylaws immediately?
And
it turns out-
my feeling is people. I don't know. I'll let you talk. Go ahead.
Well, no, they do, but I was actually surprised that the effect is kind of small. So it's a minority of companies that actually do this,
Right.
and in a result that's going to be in the next version of the paper,
Yeah.
I find that this effect is being driven by companies that had weak bylaws before the activists.
Okay.
So if you're like way behind the times and an activist shows up, you sort of get up to speed a little bit.
Yeah.
But it's not like the really tough people are cranking up their bylaws even worse.
So you have this big database of advance notice bylaws that's pretty current, and that you were able to kind of take apart and start to classify and analyze and look at individual terms and so forth. Really interesting. I'll leave. We could talk about it, but there's some detail there about how you did word searches and what the 12 most important terms are and so forth. We can cover that maybe a little later, but I know it was a fairly thorough look at all these to kind of get to these findings, but still allowing for some pretty cool analysis in the future. As well. All right. There's some other findings that you were able to kind of get to about the kinds of firms that do this. Maybe talk about that for a minute.
Yeah, so I already talked a little bit about the connection between activism and advance notice bylaws.
Oh, so I have to. I'm sorry. I asked you a question.
Yeah,
I interrupt
please.
for a sec.
Yeah.
So in addition to looking at this list of 4,000 companies and their bylaws and their share price and their financial data, you also got activist data at these companies.
Yeah.
Okay, so you went to FactSet or wherever you go, Diligent or someplace, and was able to get their 13D filings at the company and proxy statements and so forth.
Yeah, so I will say there's this professor at Duke, Alan Brav, who's sort of in the finance field, he's the expert in activism, and he's compiled this really thorough data set on all activism events.
Yes.
And he was generous enough to share his data with me through 2016, and then I supplemented after 2016.
Cool. Yes, Professor. I've talked to Alan, so he's very generous with his thinking and his time and his data.
Yeah, very much so.
All right. So you had you were able to correlate this list also to activist stuff. So keep going.
Mm-hmm. So the first thing is activism and bylaws. So one kind of interesting thing is, in general, companies that are being targeted by activists have somewhat tougher bylaws than other companies. Mm-hmm. You might be surprised by this, right? If you thought that tough advance notice bylaws were a showstopper, maybe you would think that activists only go for companies with weak ones. That turns out not to be the case, at least, first cut in the data. I mentioned the findings about whether companies, sort of ratchet up their bylaws after an activist shows up.
Yeah.
So we have those results. The other thing is just looking broadly across firms. I was surprised to find that large firms tend to have longer and more complicated bylaws than small firms. And I was surprised because I sort of expected that large firms are sort of more heavily scrutinized than small firms. They get more attention in the press. ISS and Glass Lewis are on them. Big institutional investors engage with them more. Yep. So they might be a little more circumspect and slower to adopt the new stuff. Whereas for small firms, I thought maybe it's more of a free-for-all. That turns out not to really be the case, that large firms have been leading the charge as far as innovating in advance notice bylaws, which we can talk about, why that may or may not be the case.
Sure, we have different hypotheses there. So
yeah, but I thought that was kind of an interesting gap that we find in the data.
Interesting. That's large versus small. All right.
Yeah, robust. And every year since they started being put in, it's been a consistent gap all the way through.
Right. Wow. Hey, why don't we take a quick break, and we can return to talk a little more with Ben about his research, and maybe take a little more of a look at the program in corporate governance at Harvard here at Shareholder Primacy.
This is the Free Flow Media Podcast Network, where we cover the who of the business news, because investing isn't a what, it's a who. Check out our other podcast, Business Pants, for fact-based snark covering companies and executives, and the Proxy Countdown, the only podcast that treats company meetings like sporting events. Find them on iTunes, Spotify, or wherever you get your podcasts. Back to the show.
We're back with Ben Bates of Harvard Law School and the program in corporate governance here at Shareholder Primacy, talking about some of the broader implications, Ben, of the paper. You not only laid out the theoretical framework and talked a lot about this really cool data set, which I want to ask about in a minute, but you also started to point a couple different directions. Like, what should we sort of do about this from a regulatory or a governance perspective? I think you had some ideas about how to respond to this emerging trends in advance notice bylaws. What were some of the things you were thinking?
Yeah, so I'll preface this by saying that this is actually a really hard problem, in part because in academia as well as in practice, people have really conflicting views about whether activism is a good thing or not.
Yes.
I know you've encountered
so I've heard.
Yeah. So if you talk to people on the defense side, they'll tell you that companies and their advisors, that they'll say, there's a lot of activists that are nuisances, and if we sort of ratchet up the cost that they face, this is a good thing. We're getting rid of a lot of nuisances.
Right.
Whereas if you talk to people on the shareholder side, they'll say, they'll say, this is ridiculous. Like we have a right to nominate directors. You're preventing us from exercising our right and holding
Our
companies
franchise, right? Exactly.
So this is a tricky problem, and it's hard to sort of tell empirically exactly where the optimal point is as far as making life hard for activists. So in my paper, rather than take a hard line on this, I sort of focus on, regardless of what your view about whether activism should be hard or easy, there's some reasons to think that it's suboptimal for us to have such a wide variety of, so much variation in practice.
Okay, interesting.
And so much, like the vagueness and the ambiguity of the terms.
And the diversity of terms. That's something that's pretty evident from the research. That's inarguable. And some of your ideas respond to that, it sounds like.
Yeah, so there's some reasons to think that maybe we want to slow things down. We want more standardization. We don't want things to be...
That's a great idea.
So what can we do about this? So, one idea, a couple of ideas, thinking through with this is, one idea you could do is you could require shareholders to vote on all election-related bylaws. You can say, we're not really sure whether this is good or bad for shareholders, so let's just ask shareholders whether they like what's happening or not.
So shifted into the realm of private ordering, as we say.
Exactly.
To let shareholders decide how much or how little they want of advance notice and disclosure at a given portfolio company. Just let them do it. Right now,
yes,
they don't have this vote.
They do not have votes. So bylaws, boards can adopt unilaterally.
Right.
If you required votes, go ahead.
Yeah. So they, as you said, say a board can just adopt whatever advance notice bylaw terms they want, whatever disclosure window, whatever long or short list of disclosures, and shareholders have no input into that.
Yeah, which is
general.
When you think about how much this potentially impacts shareholders voting and their rights,
Well, I'll tell you, it annoys me. How's that sound?
Yeah, you might think that there's room to change this.
Yeah.
So if we required shareholder votes, it would force ISS and Glass Lewis and big institutional investors to really pay attention to what's happening.
Sure.
And develop guidelines and policies. And then maybe we would see, what you said in the beginning, sort of more standardized forms for advance notice bylaws, and people would know more what to expect.
All right. Other recommendations?
Other ideas.
Policy.
So one that I personally kind of like is requiring companies to give activists time to cure deficiencies. This actually comes. So Jim McRitchie is
my friend Jim. He's a very active activist on governance matters.
Okay, friend of the show. Him and Abbott Cooper have been working on this. They've been filing shareholder proposals to ask companies to start doing this. I kind of like it because it matches what the SEC already does with 14A8 proposals.
Sure.
So with those, there's already, my understanding is that there's a mechanism where if a company identifies deficiencies, then you have a period of time to cure.
Right. So this has happened to me, where I submit a notice, and I think I've complied with all the advance notice disclosures. And then the company gets back to me after the deadline for me to submit it,
right?
And says, "Oops, you missed these three things."
Yeah, and so
and you're done. Unless I want to, march to Delaware and sue the company over this, which I don't want to do.
Which is super costly, right?
Yeah, right. You don't say.
Yeah.
And so basically, when what they're doing and what you've thought about as another response to these trends you've identified is requiring companies to allow activists like Lil Ol Me to have some time to respond to any kind of deficiencies that they have claimed in my disclosures.
Right. Okay. Then if a company innovates a new provision that you've never seen before, you sort of flub it up the first time you try to comply.
Right.
You get another chance. And so then maybe some of the consequences of having so many different kinds of provisions and things it ratchets down the cost.
All right. Anything else? Oh, go
Yeah,
ahead.
so the third one, this is kind of a nerdy law idea,
Yes.
but you may remember from the recent Kellner decision. So the recent Kellner decision,
Now, that was the challenge in Delaware to AIM's advance notice. But Ann and I talked about this.
you talked about it on your last
Right.
episode.
So there was this really funky activist situation where it revolved in part around AIM adopting some really onerous advance notice bylaws. That's the one where Delaware finally threw them all out of court and said, "Get out of here."
Yes.
But
yes.
All right, go ahead.
So one of the things that was clarified in the Kellner decision is that it's extremely hard to facially challenge bylaws. And a facial challenge is where there's no activist situation.
Right.
A shareholder just comes in and says, I think your bylaws,
just read them and said these are wrong.
this is ridiculous. And I want you to strike all of them
Right.
out of your bylaws for all shareholders in the future. And it's really hard to make these challenges.
Okay.
You basically have to show that a particular provision could never be applied appropriately.
Fairly or whatever.
Which,
Right. So allowing like a challenge, we'll use our favorite state court, Delaware. So allowing someone like me to go in and say, look, I haven't nominated anybody yet. I'm thinking about it. But just my read of these bylaws, they are onerously bad. And I want Delaware to agree with me and to force the company to amend the bylaws to make them a little more reasonable.
yes. So
Okay.
one idea I have to sort of tweak this is in other areas of law you have, particularly in First Amendment law, you have what's called the overbreadth doctrine.
Sure.
So the idea is that in the bylaw context, the idea would be that if a bylaw provision is so vague and so sweeping that it covers the number of ridiculous applications that it covers,
Yeah.
there's so many ridiculous applications compared to the number of legitimate applications that it's overbroad. It's just a deterrent to activism. And those types of things should be allowed to be challenged facially.
Okay. Oh, interesting. So you're kind of
On
borrowing
those
from that little element of constitutional law and applying it to this state.
And importing it into corporate law to make it easier to strike down some of the most vague stuff.
Right. So, where do you want to go with this? I have some of my own ideas about where you could take this research, other than, you're going to publish a paper, but you have this like really cool database of advance notice bylaws and you could probably update it. The code probably is, you just keep on importing new ones. So
Yeah.
talk about that for a minute.
Yeah, no, you're totally right. So we have the text of all these bylaws,
Yeah.
and it's easy to update. And I could, drop the filters and expand it to more companies. So what can we do with all this data? Obviously, my paper is just scratching the surface, right? And I'd love to hear your ideas for more projects. There's so much more we can do.
Have you thought about running them like through ChatGPT? Like
Yeah.
read all these, read these 14,000 bylaws and tell me what you think, AI.
Oh, 100%. This is somewhere on the to-do list. So there's a law professor at WashU. His name is Jens Frankenreiter, and he's a wizard about taking legal documents and running them through ChatGPT and using machine learning tools to extract valuable information. And so I've had some conversations with him about there's got to be something we can do, and he's sort of on to the advance notice bylaw thing. So I think this is very promising area.
So
for
we
research.
can even try to get more new. I mean, right now what we've done is we've kind of classified 12 individual parts of advance notice bylaws and sort of identified presence or absence. But we could really do some fun stuff by actually having a bot read them for us.
Oh yeah, there's so much to do there. So
right,
I'm
great.
excited about that
All right,
possibility.
go ahead.
There's we can also look. I'm interested in the relationship between advance notice bylaws and other defenses.
Oh.
Are they substitutes for each other? Are they used together? If a company has a staggered board, do they not bother with the bylaws, or do they?
Oh, that's a really interesting question. How does it relate to poison pills or dual
these
class
anti-activist
shares?
pills. Yeah, dual class is also I like that a lot.
All right.
And then another thing is the role of law firms in all of this.
Sure.
Do you have sort of if you're one firm, you have sort of a house set of bylaws that you like to give to all of your clients? Are there, how do these drafting innovations spread? Does one firm innovate and other firms borrow?
Sure.
there's a lot of these things that I think just in understanding how legal innovation happens,
Right.
that I think you could do when you have the text of these bylaws, you can learn a lot.
Right. You can start to figure out which ones are sufficiently similar. You can sort of say, okay, these 10 companies look like they hired Sidley. These 5
Yeah.
firms look like they hired Paul Hastings, to use 2 firms where I know people.
Yeah, no, and I think it would be interesting to see if you can sort of tell that from the text.
Yeah.
Anyway, so there's sort of a line of research there that we could look at.
All right. Let me, we're starting to run out of time, but I have some other stuff I want to ask you. I think you started hinting at this earlier, but let's go back to the very beginning. How did this subject interest you? I mean, sure, hanging around Lucian and so forth, there's probably plenty to think about. But when did you tell us a little bit of the story about how you got involved in advance notice bylaws?
Yeah, I mean, there's not a super inspirational story here, other than when you're an aspiring academic, you've got to write papers, right? This is the currency in our profession. And so I was looking for ideas to get started.
Yeah.
And I think I got turned on to this idea reading our blog.
Reading the Harvard blog.
Yeah, I mean, so like law firms are starting to write memos about advance notice bylaws, and there's these cases that are coming out. And so I thought, I wonder what's going on here.
Okay.
And then last year, so Lucian Bebchuk, who I work for, teaches a couple of advanced corporate law seminars, and he often has guest speakers come to class and talk about, what's going on in practice. And one of the speakers was a lawyer who works in the area, and he talked about advance notice bylaws and what's happening and how crazy
how this was changing. Yeah, there was
how the battles are starting to happen. And I thought, okay, this really is something that is interesting and going to be interesting for a few years.
Right. And there's even disputes among company attorneys. I wrote a post a year or two ago where one firm, I think it was Paul Hastings, was pretty aggressive in advising clients about adopting fairly a lot of disclosure. And Sidley wrote a memo to its clients kind of warning off and saying, I think it's possible to get too harsh here. And I wrote a post that kind of compared the two firms. So maybe you may be thinking a little bit about that, I suppose.
Yeah, no, I've in doing my research, I've tried to call a lot of lawyers on both sides, the activist lawyers and the defense lawyers, and ask them their perspectives. And I have gotten a really wide range of perspectives, everything from gung-ho, on both sides. It's pretty fascinating.
So what have you heard? I mean, the paper's been out there a little while. I've done my share to my effort to try to let people know. What have you been hearing?
I mean, the reception's been positive. I think as somebody who really likes being in the weeds on corporate law, I thought it was interesting, but I was surprised by the extent to which people picked up on it and thought, this is really interesting, which I was pleased to see. And I've gotten people who have reached out to me since I put the paper out there saying, I've got stories about advance notice bylaws. Let me tell you what's happened to me, or I know about this case or something.
Right. Take good notes. That's really interesting stuff.
Yeah, it is. It's super fascinating, and so we'll see if some of it makes it into the next version of the paper. Or
right. Now there's got to be one or another big law firm that knows the Harvard program that would love to access to a database of 13,000 examples of advance notice bylaws from 4,000 companies. So that in itself is probably pretty useful to some of the and there's probably other academics that are seeing this and saying, "Oh, let's talk."
Yeah, no, I hope to collaborate with other people in the future about some of this stuff. I think it's exciting.
Let's talk for a minute about the program. Are you working on other stuff besides an advance notice bylaw paper?
I do have a few other things kicking around. So I have basically 2 streams of research.
Okay, that's what I want to know.
Yeah, so one stream of research is this corporate law, activism, shareholder voting stuff.
Yeah.
So I have advance notice bylaw stuff, and I also have another project that I'm trying to get off the ground about how companies use the timing of elections and when polls close to potentially get an edge.
Oh, polls like at the AGM polls.
Yeah, so your Broadridge tells you you're behind in the vote count when you come to election.
Yeah.
Do you just adjourn the meeting before
How do
polls
people
close?
manipulate that?
How do people use this? Or do you just postpone the meeting?
Oh, interesting. There's,
So anyway,
there's probably not a very large sample but it's the case study information. There's got to be really cool.
Yeah, and the legal information's interesting. And it's not just activism where this happens, right? And all kinds of votes. You can imagine there's reasons why
Sure.
you might want
Oh, sure. Like, not a proxy contest, but it happens when they're trying to get a quorum, or when GameStop's trying to get a vote on something. Oh, interesting.
or prove an executive compensation
Right.
package, or whatever, equity compensation. So that's one stream.
Yeah.
The other stream is I have a stream of stuff that's focused on the SEC and securities regulation.
Oh, sure.
And that's a little bit more. I have a paper that's up on SSRN about private fund regulation,
Okay.
and trying to sort of learn something about the cost based on advisors' behavior. And then a project that's super early stages about insider trading policies at firms.
All right.
So anyway, there's a few
Interesting stuff, not necessarily directly in the middle of the activism world, but
yeah, but just another stream.
So it sounds like your next move is where? Is academia? Are you going to go back to a law firm? What do you want to do next?
Long-term academia is the next plan. My plan is to go on the academic job market next fall.
Oh,
And so I'm still.
so a year from now,
Yeah.
you'll be this paper will be in the books, a couple others, and you'll be interviewing with all the big law schools.
That's the plan.
All right, go be a professor.
Yeah.
I love it. Well, this has really been very fun. I hope you have thought so as well.
No, it's been a pleasure. Thank you so much.
You're quite welcome. There's a lot more to cover next time, but thanks for talking about these subjects. So this is Shareholder Primacy, hosted by normally Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Instead of Ann, as we mentioned, I've been talking with Ben Bates of Harvard Law School and the program on corporate governance. You can find me, Mike, at theactivistinvestor.com, and hiring committees at law schools. You can find Ben at pcg.harvard.law.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we'll talk again soon.